Colby Springer. I will be the moderator for the second panel of the day, Digital Dossiers, the Protection of Personal Information. I am a graduate of the Santa Clara University School of Law and also a former member of the High Tech Law Journal, so I am proud to see so many people turn out today. So I wish to extend my congratulations to the board and the High Tech Law Institute for putting on a very successful program here today. I think all of us at some point or another have been in front of their computer, in front of their TV, their TiVo, for example, has been mentioned several times today, when all of a sudden that commercial pops up that is uniquely tailored to some of your personal interests. And as was referenced increasingly at the end of the previous panel, the gathering of information, personal information, the use of that information, distribution of that information, I think is becoming a more and more prevalent part of our lifestyle, especially in this, as it's called, the digital world. We are very privileged today to have a great panel speaking with us today on the issue. Our first panelist is Dan Solove. He's a professor of law at the George Washington University. He has the author of a new book, Digital Person, Technology and Privacy in the Information Age. We also have with us today James Nehf, who is a professor and Cleon H. Foust Fellow at the Indiana University School of Law. Professor Nehf has written numerous articles and book chapters on contracting law subjects, especially information privacy in the digital age. Also speaking with us today is Chris Hoofnagle, who is the West Coast Director of the Electronic Privacy Information Center. And he's also a non-residential fellow at the Stanford University Center for Internet and Society. We're also privileged today to have Matt Parrella, who is the San Jose Branch Chief and Computer Hacking and Intellectual Property Unit Chief with the U.S. Attorney's Office here in San Jose, who can offer a unique perspective on the legal aspects of digital or of information collection. And last but certainly not least, we have Anita Ramasastry with us today. She will be speaking about commercial data and government decision-making and computerized passenger screening in particular. She's an associate professor of law and the director of the Shidler Center for Law, Commerce, and Technology at the University of Washington School of Law in Seattle. Without further ado, I'd like to turn the panel over to Dan Solove.
I'd like to talk to you a little about what I call the other you. And you might be wondering, well, what exactly do I mean by the other me? We're all living with a digital counterpart of sorts, a digital person who resides in various computer databases. And the digital person isn't made up of flesh and blood like we are, but of bits and bytes of data that are being aggregated together. And increasingly what we're seeing is that important decisions about our lives are being made based on the digital person. What happens to our digital person in the world of computers and cyberspace is increasingly having effects on our lives in real space. What I want to discuss today is just whether or not this poses a problem. And if it poses a problem, why? And how do we understand the problem? Because how we understand the problem affects how we address solutions to that problem. But today there are hundreds of records that describe our lifestyle. And I always say, in order to live in the information age, you've got to plug in order to join in. That means that if you want internet service, you've got to sign up with an internet service provider. You want telephone service, you've got to get an account with a telephone company and a cell phone company. Insurance, you need to deal with an insurance company, and so on. And all these companies have records of us, our accounts, and our transactions. And increasingly, there are companies that we do not do business with. Companies that we might never have heard of, but they're increasingly compiling information about us in their own dossiers. What's being done with this information is it's being used to, in certain ways, sometimes just market products to us, but in other ways it's being used to determine whether or not we get a license, a job, or a loan. One example of new ways that this information can be used to affect our lives or make decisions about us is Amazon.com's book recommendation service. And I actually really love this, in fact. I have shopped with Amazon.com. I guess I confess I shop with Amazon.com. I've been shopping with them since 1997. I am a bookaholic. And so I bought probably around 800 or more books with Amazon.com. As a result of the fact that they have like almost 10 years of book purchases from me and this voluminous hundreds of books, they actually have a fairly good profile of my reading interests and my reading habits and what I'm going to like. And then they create a page just for me where they recommend books for me. And I think they actually do a very good job of it. They do a much, much better job than my relatives ever do at picking out what it thinks it's going to want. And what the government, I think, is increasingly interested in is looking at, well, how can we use a technology like this? Maybe if Amazon.com has me pegged, well, maybe we can use the same kind of techniques, looking at patterns of data to determine who is a criminal, who might be a terrorist, or other things about individuals, who at least is suspicious and should be investigated. In late 2002, a project by the Department of Defense known as Total Information Awareness came to light. What this envisioned was creating a gigantic database, sweeping up information from a variety of different sources, travel records, financial records, education records, health records, and more, putting it all in a big database, and then running various computer algorithms on that information to look for various patterns, to see who was naughty and who was nice, who looked like they should be investigated further as being a potential terrorist or whatnot. The project had this website designed by one of the geniuses over at the Department of Defense who thought, like, let's put up this cool logo. And the logo had a pyramid, and at the top of the pyramid was this eye. And beams of light were emanating from the eye on a globe, and below it, it said, "Knowledge is power" in Latin. Well, this created a big outcry. People were very upset when this when this broke as a major news story. A number of civil liberties groups and privacy advocates criticized it. William Safire, a conservative columnist for the New York Times, had a blistering op-ed attacking this program. The website was quickly shut down. The logo disappeared into the ether. And Congress ultimately voted to deny funding for the program. So total information awareness was dead. It appeared to be this great victory for privacy. However, it's far from dead. It's been resurrected in little bits and pieces in various government agencies. Government agencies continue to explore data mining. They continue to engage in it, and they continue to explore it. And for some time, what we're seeing, too, is that the government has been contracting with various businesses to acquire databases of personal information. There's one company you might have heard of, and it was in the news very recently, ChoicePoint. And actually recently had the settlement with the FTC for something that happened that it announced last year, that it had sold records on about over 160,000 Americans to identity thieves. Well, this company, some of its products are aimed at government agencies, and it has contracts with about 35 different federal agencies, including the FBI and the IRS, to supply it with data and to supply it with analyzed data as well. The government doesn't have to do total information awareness. ChoicePoint will happily do it for them. And beyond ChoicePoint, in today's information age, there's so much information in the hands of businesses, so much information in the hands with Amazon.com and employers and retailers and stores and so on. And all this can be readily gathered by the government, as we are seeing right now in the Google case. Today we're closer, I think, to total information awareness than we might think. But so what? So what? What's the problem? And in the earlier panel, a lot of folks were talking about, well, what is the problem exactly? Why should we care about this? Do we care about this? What is the source of this just general anxiety? So it might be, well, people just talk about, yeah, it's invasive of privacy, 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 privacy. I feel a little anxiety, and then it's like, okay, now I go on with my day. And I think, like, how do we explore what exactly is the nub of this problem? Is this just anxiety that ultimately burns off like the clouds in this area or the fog in this area? Or is it something else? Is there something more palpable, something that we really should be concerned about? And so what I want to do is talk about some of the old notions of privacy and then contrast them with some other ways of understanding privacy, because I think how we see privacy actually has a very important impact on how we understand this problem. So a lot of commentators, as especially in the dawn of the rise of the commercial internet, a lot of commentators and journalists and politicians would immediately invoke George Orwell's 1984. This is Orwellian. This is Big Brother. And for those I'm sure most of you are familiar with 1984, but for those of you who aren't, what this novel envisions is this terrifying totalitarian world where every facet of life is controlled by Big Brother, which is the government. And everywhere it is watching you, surveilling you. There are posters with this caption saying, Big Brother is watching you. The primary technique of surveillance is what's known as the telescreen. It's a bilateral TV set. As you're watching it, someone from Big Brother could be watching you at any moment. And I think one reason why this metaphor really took hold is that as you're typing stuff on your computer, right, they're watching back. They can see what you're doing and how you're surfing and how you're interacting with the website, and i.e. gather information about you. So to some extent it has properties that resemble the telescreen a bit. But I actually think that this does not adequately capture the problem that we face. The Big Brother metaphor sees the problem primarily as one of surveillance. And the idea is that the problem, they say, is it inhibits people. That's why surveillance is bad. It chills behavior. It means that people will self-censor their activities. They will not do the things they ordinarily would because they're afraid that they're going to be watched. But there are a lot of problems with understanding the problem in this way. I don't think that's what's really the problem when it comes to databases. One thing about Big Brother that I don't think quite fits is that it envisions a centralized authority, the centralized authority that aims for absolute control and absolute domination. But the digital dossiers constructed by businesses aren't controlled by a central power. They're decentralized. And the goal of businesses isn't to oppress us. You know what they want? They want us to buy stuff. That's what they want. They want to sell stuff. They want us to buy stuff. They want to measure their audience shares. They don't want to oppress us. They don't want to stop us and inhibit us from buying things. They just want to find out what we want and then how we can get us to buy more of it. And I think the government is also a far cry from Big Brother as well. There are certainly abusive government officials who have engaged in abuse, but a lot of government officials are nice people, believe it or not. And their goal isn't to oppress us. They want to do good. They don't have the malevolent aims that Big Brother has. And a lot of the information that is being gathered isn't all that intimate. So what that I like to drink Diet Coke rather than Diet Pepsi, or vice versa? So what that someone prefers Puffs tissues to Kleenex? Does it matter? Is this information all that telling about a person's life? Well, if you look at the information, a lot of it doesn't seem to be that intimate or telling. It's just the product someone might buy. Well, I actually want to show a different way of seeing this problem, and I invoke a different book, and one of my very favorite books, and it's Franz Kafka's The Trial. And it's a book people are less familiar with, but I'd like to just talk briefly, for those of you who are not familiar with it, what the book is about. It's about this guy. He wakes up one day, and there are these officials in his house, not even sure where they came from, and they tell him he's under arrest. And Kay says, I don't quite remember doing anything wrong. He tries to think what crime he could have committed. He can't figure it out, so he asks them, well, why? Why am I under arrest? They're like, we don't know. You're just told to come here and tell you you're under arrest. Now have a nice day. And they leave. And what happens is throughout this novel, he spends his time trying to figure out why he's been under arrest. what he learns is that the court system has constructed a vast dossier about his life. They've constructed this file, and they circulate it among the various court officials. He never finds out what's in his file. He has no idea what's in the file, or anything for that matter. And in the end, what happens is that he is seized by two officials in the middle of the night, and he's executed. Well, obviously, I don't think the metaphor is accurate in that. I don't think we're going to be seized in the middle of the night and executed. Although I do think, though, that the folks at RIAA and the motion picture industry would certainly resort to the tactic if they could. But I think that what the trial captures is this sense of helplessness, this frustration, and the vulnerability when these large organizations have a dossier of information about people's lives. It's not clear throughout most of the trial that what the motives of the court are. We don't know what their motives are. We know very little about what they're going to do with this information. Why they have a file on him, we don't know what's in the file about him. We don't know what's going to be done with the information. It's just there, and it circulates, and Joseph K. is out of the loop. He is shut out. All of a sudden, then, decisions are made about Joseph K. Important ones, i.e. his life or death, are made based on the data. But he's never informed. The irony of the trial is that he never gets a trial. Trial, you actually hear the evidence before you. You have a chance to respond and participate and actually have it heard. He never gets that. The data is collected about him in secret, and ultimately decisions are made about him in secret, and then the final resolution. And I think this better captures what is wrong with the databases. It's that we're out of the loop, and yet this information is increasingly having effects on the way we live our lives. Another older conception of privacy is what I call the secrecy paradigm. This is another outmoded way that courts especially have understood what privacy is all about. And the idea is this, that privacy is about keeping concealed secrets. But once you expose something to other people or to other entities or to the public, you no longer can expect privacy. So privacy is the hidden world that we envelop around us. But once it's out there, and the cat's out of the bag, there's no privacy. That's sort of the notion. And this has actually been embodied in the law. In particular, in Fourth Amendment law, there's a doctrine that's known as the third-party doctrine. And the way this works is as follows, that if you expose information to third parties, if you give records to your bank or another business or company sees your information or has your information, you cannot have a reasonable expectation of privacy in that data. What that means, for those of you unfamiliar with Fourth Amendment law, is that there is no Fourth Amendment protection, because the Fourth Amendment protection will only attach when you have a reasonable expectation of privacy. So in effect, what the Supreme Court has said is whenever a third-party business has your information, you can't expect privacy in that information, and you don't get any Fourth Amendment protection in that data. Now, the problem with this understanding of privacy, these cases came out in the 70s in a series of cases. The problem with this understanding of privacy is that in today's age, so many third parties have our information. In the past, you'd have your papers and all your information would be in your home. And it would all be in your home. So if you wanted to find out something about somebody, you had to go into their home where you had a lot of Fourth Amendment and privacy protection. But now, so much of our data exists outside our homes, in digital format, in the hands of these various companies. Speaking, doesn't need to enter my home to find out what books I'm reading. It just goes to Amazon.com. Wants to find out what products I buy and where what I purchase, just go to the various aggregators and companies that have collected that data. Go to my credit card company and try to get the information. You want to know about my internet activity? You don't need to get it from my home. You can just go to my internet service provider. Subpoena Google, for example. and you can find out my search history if you want it. Or you can do it the way the government's doing it now, which is, okay, you can just get it de-anonymized, and then if you find something you might like, you can just go back and say, hey, now we don't like people who are searching for this. We want to know who they are. So what we're seeing here is that massive amounts of personal information are increasingly finding their way into the hands of third-party businesses. And they're being assembled into these dossiers where decisions are being made about us. The government is increasingly interested in tapping in to make its own decisions affecting our lives, the data mine itself. And the Fourth Amendment is left sitting on the sidelines without providing any protection. And unless we abandon this understanding of privacy as secrecy, we really won't have much meaningful Fourth Amendment protection in the future. Well, there's another understanding of privacy, and that is understands privacy as violated, a wrong, I think, understanding of privacy. It understands privacy as invaded, as what I call the invasion conception. What this means is that privacy is violated by a series of invasive actions. There's a person who's doing the invading, and there's an invadee. And the idea would be a peeping Tom would be an example of this. Someone peeps into your window and sees you in the nude. There is a wrongdoer. The peeping Tom is the evil person violating your privacy. You experience a violation of privacy that courts understand. They understand the embarrassment of a peeping Tom. But with databases, there often is no overt injury. You experience harm when these companies, like the fact that ChoicePoint has you in its database. Every one of you is in ChoicePoint's database. They are collecting information about you. Do you feel harmed by that right now? Some people don't even know about it. So a lot of times we don't experience this direct injury when this data is being aggregated about us. And under this traditional view, courts struggle to find a harm, a cognizable harm, to address it. Well, I think one aspect of the harm, or one other way to understand this problem, is what I term the aggregation effect. And it sort of works like this, that we give out these bits and pieces of our information throughout the day. So you might tell someone a fact here, you go to the store and you buy, a Diet Coke there, you go here and you buy a book at the bookstore, and each individual thing isn't all that telling. Like, okay, so who cares that I bought a Diet Coke? Who cares that, what kind of muffin I ate over there? Who cares about this particular product? But when you take all this information and you put it together, you assemble the pieces, the whole becomes greater than the parts. You start to form a picture about a person. This is the idea behind data mining, is that when you get a lot of data, you can start mining it for interesting other nuggets of information. That when you put 2 and 2 together, to some extent, you get more than 4. You get more synergies when you combine data. And so in isolation, we think that each particular piece of data and information we give out isn't all that telling. But the problem is we don't see the bigger picture. And that in combination, it's actually more invasive. And the other problem, too, is when we give out data, we don't know what the future uses are. Because we're often not clearly told what they may or may not be, or what might happen with their information, or whether the government might be seeking to access search information from Google, and so on. And so we think when we give it out, oh, it's not so bad, what could possibly happen, whatever, they seem like a trustworthy company and whatever, and they're not going to do anything. But who knows what's going to happen 3 or 4 years down the road when all of a sudden there's this new cool use of the information that may be very invasive, but could be very profitable to a company, or it could be very interesting to something that the government is interested in. And so the problem is that at time 1 we make these decisions, but we don't know what's going to happen at time 2. Well, I'll wrap it up here and just sort of say just a couple things in conclusion, and that there are a lot who say, there's very little we can do about privacy today because people want the conveniences of the information age. They want to have internet service. They want to have cell phones, right? You try living without a cell phone and internet service and without insurance and completely and utterly off the grid. You live like Ted Kaczynski in some shack in the middle of the woods. And yeah, that's a choice, right? You can choose to live in the middle of the woods in a shack, or you can actually choose to sign up for these services and, of course, with each one, give away a little bit of your privacy. But the fact is, this is just technology, some say. Technology, just the facts of life today. There's nothing we can really do because, after all, technology must march on. You can't just smash up all the computers in the world, and we can't go back to the Stone Age. So you know what? That's just life. So the famous quip by Scott McNeely of Sun Microsystems is, you have zero privacy, get over it. Well, I think that this is wrong. And I think it's wrong because I think that there's a lot we can do about privacy. Technology, I think, exacerbates existing problems, but it's often not the cause of the problem. So just stopping technology is not the answer. The problem, really, I think, when you boil it all down, comes down to various practices by the government and by business. It's by what they are doing, the things that they are doing and how they are using information. That is very problematic. It's the fact that we're shut out of the process. But we can do something about that. It's very hard. We can't stop technology, but we can regulate business practices and we can regulate the government practices. So to sort of pin all the problems on technology and make technology the villain is the wrong thing. The real problem is that we have these practices that are not adequately addressed, that are not adequately being looked at and limited and controlled, and the people are increasingly shut out of any ability to participate in how their information is used. And so I think there's a lot we can do to protect privacy in the information age. But in order to do so, I think we really need to think hard about our older understandings of privacy and how to modernize these understandings so that we can effectively protect privacy in the information age. Thanks.
Hi, I'm going to talk about a common theme that has come up already a couple times, and that is, why don't consumers take care of this problem themselves? Why can't market forces yield kind of efficient, fair privacy practices? And this is a common refrain that our current Congress takes. The FTC has taken, at least since the Bush administration took charge some 6 years ago. And Scott McGrew earlier was talking about it as well. People talk a good game, but they don't police their personal information all that well. Why is that? Well, the proponents of letting market forces work in this area, and there are many, point to things like ChoicePoint, for example. Look, the market's working. They've been exposed. Their security breach was exposed, and they're paying the price. What that tells me is, or it makes me ask the question, how many more companies out there are like that, where there are similar security breaches we're just not hearing about? Or they'll say, look at all the opt-out opportunities we have. That's the market at work. It's free choice among consumers. Now, everybody in this room, you're either law students or you are really interested in privacy as an issue. So we've all opted out from all of the insurance company and bank and internet sites and retailers that we deal with. We've all taken advantage of that, right? But what about everybody else? They're not quite so savvy. Or, and this is going to be my main focus, look at the proliferation of privacy policies. They're everywhere. You can't go anywhere without having a privacy policy stuck in your face. And of course we all read those privacy policies so we can make informed choices and decide that we will do business with the strong privacy providers and not do business with the weak privacy provider. Well, of course, nobody does that. The question is why? Well, behavioral economists study this kind of stuff. Why do people act the way that they do? And their studies are interesting. On the one hand, you will find countless studies that show people really care deeply about privacy. They really value their personal information. And they conclude, then really all we need to do is give people informed choices and they will make those decisions. But if that's the case, if people really do value their privacy, why don't they opt out? Why don't they read privacy policies? Well, there are a lot of good reasons that behavioral economists have shown as well, and I'm just going to go through a few of them. One is, of course, it takes time and effort to protect your personal information. What behavioral economists would say is that one rational goal of making a decision, whether to share information, which website to go to, which bank to use, one rational goal is to make a completely accurate decision, make the best decision, taking in all the factors. But another rational goal is to minimize cognitive effort, they will say. People don't want to have to spend a lot of anxiety and time thinking about making decisions. In fact, studies have shown, and this is interesting, to the extent that somebody kind of forces you to expend more cognitive effort to make a decision, people tend to view that alternative less favorably. Which tells me it's not in anybody's interest to make you click on a button on a website to check out their privacy policy before you move on. It's just going to make them a less attractive alternative. Second thing these studies will show you is that people don't like to make uncomfortable comparisons. It creates emotional discomfort when you are required to make uncomfortable trade-offs, to value things that are really incomparable. And that's what we're really called to do when we're called to decide which choice to make based on who protects our information better. You have to ask yourself, what is my information worth? And is it worth more than the benefits that maybe some weak privacy provider is offering you? You have a choice between two news websites. One has strong privacy policies because you've taken the time to read it. The other one has weak privacy policies. But the weak provider has some really cool content. Well, how do you make that decision? How much is your privacy worth? It's going to create some discomfort with people because they don't know how to make the choice. And these studies will show, again, to the extent that you make people, force them to have emotionally difficult decisions, you will tend to disfavor that alternative. So it's not in our interest to force us down that road. In addition to that, you have the aggregation effect that Daniel was talking about. You might think, well, I'm only giving innocent information to this site, so even though they're a weak privacy provider, I like their content, I'll go with it. But who knows what they're going to do with that information, where it's going to end up. The key here, though, is that businesses know this too. Businesses often fund these studies by behavioral economics. They know how consumers make decisions, so what do? They rely on things sometimes referred to as heuristics, shorthand ways that consumers make decisions. One is very well known, one is called framing effects. People tend to take things at face value. So, you go to the Parisian website, the department store. You click on their privacy policy, and what does it say? In big, bold letters, just between you and us. Sounds good. They're going to protect my personal information. The problem is, you read the fine print, you see how they define the word us. Us includes not only Parisian, but all of the other companies and store chains that Saks International owns. But it doesn't stop there. Us also includes any other company or marketer that Parisian or Saks International thinks would be of interest to me, which would include just about anybody. They also take advantage of inferences. People will tend to think, well, Parisian is a nice store. They have good clothing, they've treated me well, they must have a good, strong privacy policy. And that, of course, may or may not be the case. Now, if people cannot effectively police their personal information and make these choices, the question then is, well, how do you respond? What are some alternative responses? One theory is we just need to be patient. This is still a relatively new phenomenon. Digital databases, we're all getting used to it. Let's let time have its positive effects, and people will be able to police their interests better. And I want to talk about how this might work in 4 different areas and some of the weaknesses in those. One is people will say, well, the market will work because strong privacy providers will advertise. They will market that we are a strong privacy provider, use us rather than them. Now that works for some attributes. You know, our prices are better than theirs because you can check it out. Our quality is better than theirs because you can check it out. How can you evaluate whether somebody's privacy practices are stronger than somebody else's? Most personal information problems, as Daniel was saying, take place in secrecy, behind closed doors, out of public view. Even if you read the privacy policies, you're not going to be able to tell necessarily who is better at protecting your information. Another thing people will say, personal experience. As people have experience in this area, they'll get burned a few times, they'll make mistakes, they will learn, and they will not frequent the weak privacy providers as much, and the market will yield a good result. The problem there is this isn't like, product warranties. If you buy some merchandise from a company and they have a cheap warranty or they don't honor their warranties, you learn about it after the product breaks and they don't give you a refund, and you don't do business with them again. But if you decide to share your personal information with somebody, and maybe later on you get a bunch of spam, you get a bunch of junk mail coming in, or your identity gets stolen, how do you know what was the source of that? How do you know where your mistake was? Even if you made a mistake, how can you learn from your personal experience? Even with Choice Point. Thousands of people got these letters from Choice Point saying your personal information has been compromised. What are you going to do with that information? Well, you monitor your credit reports, but let's say you do get some identity theft problem later on. How do you know it was Choice Point's fault? And even if it was, what are you going to do about it? You don't do business with Choice Point anyway. They don't get their information directly from us. How do you know who not to do business with to keep your information out of Choice Point's database? Third thing people will talk about is, well, there are some market signals developing. Privacy seals. If it's hard to make these comparisons, there are these privacy seals. It's kind of like the good housekeeping seal of approval, say on a website or for some company. It says they comply with, the Better Business Bureau's privacy guidelines or trustees' privacy guidelines. Well, it does make it easy to compare, but easy to compare what? The problem with these market signals is the standards are not that rigorous. So somebody might have a privacy seal that says they comply with some fairly weak privacy standards. Another company has no privacy seal, but might very well have strong privacy practices. And the seal becomes meaningless. And the market incentives are not heading in that direction. How do these privacy seal companies make money? Through subscribers. Who pays them? Not the consumers, the businesses do. How do you get more subscribers? By having really tough privacy standards? I don't think so. Fourth, people will say, well, technology will solve the problem. If it's largely a technological problem, let's let the tech wizards have at it, and they'll protect us. And there are programs like Anonymizer, and there's P3P technology, and all this stuff people tout. Well, part of the other problem there is it's only going to work for kind of computer sharing of information, visiting websites and the like. It's not going to help with the sharing of information outside of the computer world. The second problem is the technology incentives so far are heading in the exact opposite direction. There's a whole lot more innovation out there on how to get our personal information and how to aggregate it and sort it and do it behind our backs than there is people trying to come up with ways for us to protect our information. Another problem with that is it would take a large-scale educational effort. I mean, I would imagine that a good number of the people in this room don't even know how to block cookies on their computer, much less use P3P technology. And we're a pretty educated and pretty savvy group. And another problem with that is even if you use this technology, so let's say your computer's set up so when you visit a website, if it doesn't have privacy practices that match your preferences, then a little alarm's going to go off. What are you going to do with that information? If it's a website you really want to visit, you've got to now make that uncomfortable choice and expend some cognitive effort. You've got to decide, all right, this is a website that doesn't have my kind of privacy. Is it worth dealing with them for the benefits that I think I'm going to get? Again, it's an impossible comparison to make. So where do you go from here? Just a few words in closing. I'm convinced, and many people are, that the market is not going to provide optimal solutions here. Now, you can impose mandatory standards, as Daniel and others have proposed. Government standards saying, look, these are the privacy rules we're going to have in this country, and they're going to be strong privacy rules. And I tend to agree with that. This is a societal problem. We don't deal with other societal problems by saying, people, protect yourselves. We don't say protect yourself against environmental degradation and sue somebody when you have some disease caused by toxic waste. We don't say protect yourselves against workplace hazards. This is a societal problem too, and it deserves societal resolution. The risk there, and what's holding back on that, is that it would be overkill. We would lose some of the real benefits of the information society, and the net result would be we're worse off. It doesn't mean you don't try, though. In the interim, what I advocate is more aggressive case-by-case enforcement by the FTC and state attorney generals and other enforcement agencies. It should be an unfair and deceptive practice to say just between you and us when you read the fine print and it ain't so. It should be unfair and deceptive to proudly display a privacy seal when your privacy practices are actually pretty weak, even if you're complying with the seal's requirements. It should be an unfair and deceptive practice to collect information in a survey or a registration card when you intend to use it for other purposes without clear, conspicuous disclosure and consent, or more generally, to profit from the sale of information to third parties without the express consent of the people from whom you're deriving the information. Not opt out, opt in. Or to have security practices that are not reasonably designed to limit unauthorized access to the personal information you've aggregated. Now, case-by-case resolution of these problems is slow, but it has the advantage of being incremental. It has the advantage of being to adjust to changing circumstances over time. And in my view, with some more aggressive enforcement action, you're more likely to get fair information practices to emerge that are both fair to consumers, fair to businesses, and more efficient overall. All right, thank you.
Good morning, everyone. everyone. I'm Chris Hoofnagle from the Electronic Privacy Information Center. EPIC is a not-for-profit research center. It's based in Washington, D.C., and last year I came out here and opened our first satellite office of the organization, our West Coast office. We're online at epic.org, and our mission basically is to promote privacy, and we do that in several different ways. On one hand, we use the Freedom of Information Act to learn more about what the government is doing, how they are using our personal information. And on the other hand, we work as a resource, an encyclopedia, if you will, of privacy, so that legislators and other policymakers can learn more about the issues and make more educated decisions about what regulation should look like in this field and what public policy should look like in this field. If you're interested in doing an internship with us, please note that we have paid summer internships, and we'd love to have you apply. I think the application deadline is pretty soon. You can go to epic.org and learn more about that. I wanted to cover 4 different issues in my presentation today. There are a lot of different things that one could talk about when it comes to digital dossiers and commercial data brokers. I'm going to limit my comments to just these issues. The first is what is a commercial data broker? The second is how government uses commercial data brokers. The third is how the private sector uses them. And finally, I'm going to talk a little bit about California and how California legislators tried to address the problem of commercial data brokers last year, but ultimately failed. A commercial data broker is a company that collects personal information from many different sources, both public and private. So they go to the city hall and they get property records, they get marriage licenses, they get all sorts of other types of information, and they bundle it up into reports that are keyed to you by your name, by similar spellings of your name, by your social security number, and by your address, and then they sell it to unaffiliated third parties. There are a number of commercial data brokers in the United States, although there's been an incredible amount of buyouts in this field. The main players are ChoicePoint, which has been in the news a lot lately, Axiom, which is a Arkansas-based marketing company that has grown into this field of selling data to the government, Experian, which is another marketing company that also has some commercial database functions, and LexisNexis. And probably law students in here are probably familiar with Lexis. If you browse around in Lexis databases, you'll see that there are personal information databases available to you. And you probably can use them free. You might want to try doing a search on yourself to see what comes out. So commercial data brokers are these companies that you don't have a relationship with, but they have a relationship with you, as Professor Solove said. They collect data on you, and there are very few rights that you have in regard to these companies. Back in 1999, to stave off legislation called the Gramm-Leach-Bliley Act that ultimately passed, commercial data brokers created a self-regulatory scheme to allow individuals to have some privacy rights with respect to their data. And that self-regulatory scheme allows you to have access to your dossier. So you can write to ChoicePoint. You can actually go online to choicepoint.com and request your dossier. Because of everything that happened last year, you can do that free now. So you can actually get a copy at no cost. They don't give you correction rights under this self-regulatory program. And they say they give you opt-out rights, but they don't really. They say you can opt out of sale of your personal information, includes your social security number, to the general public. But the key there is the general public. ChoicePoint, Axiom, and Experian, they don't consider their clients to be the general public. They're special in some way. So you can't actually opt out of the sale of your data. So what does your report look like? If you take my advice and you go to choicepoint.com, you'll get a dossier about your life. I'm 31 years old. I pulled my report again last year, and I think it was 18 pages long of personal information. And generally what's in one of these dossiers is every address you've ever lived at since you've established some type of credit history. So it's very useful when you apply for the bar and you can't remember where you live. It's very, very helpful. It has your social security number, your date of birth, your mother's maiden name, all these kind of key identifiers that institutions are always asking you for and quietly selling, often not telling you about that. If you've ever owned property, your property records will be in your choice point report. If you've ever owned certain types of property, for instance, an airplane, a car, your car will be in there along with license numbers and VIN numbers, or a boat. If you've ever held any type of license, occupational or otherwise, hunting, etc., that will be in there. And if you've ever had any run-ins in the law, that information will be in there too. Any arrest records, any conviction records will appear in your choice point report. And because choice point is a private sector entity, even if you have your record expunged, they don't have to remove it. They can leave it in there. And so in a way, these companies can kind of subvert the social forgiveness that's inherent in expungement and sealing of records. And then finally, one of the most interesting things about your choice point report is it will include information about your family and your neighbors. So you'll get a list of all your neighbors, their home address, and their telephone number. And you'll frequently get information about your family members. And in fact, my choice point report has the social security numbers of all my family members in it, which is useful if I ever want to steal their identity. Who uses these reports? All sorts of people use them. In fact, the reason why the reports look the way they do is because they grew up in the skip collection industry. They grew up for companies that were trying to track you down and to get money out of you. And how else do you do that? You want to know everywhere they've lived, and you want to know all their families' names, and you want to know all their neighbors, so that you can go knock on that neighbor's door and say, where is this guy, Chris? Or you can go hunt Chris down when he's hiding out of his mother's house or an ex-girlfriend's house. So that's how these products grew up, and lots of different companies now use them, including private investigators. Banks use them now under the Patriot Act. Banks have to do a lightweight background check on you. So they all use choice point to check out your background to make sure you're not a terrorist. And finally, the government uses choice point. And the reason why the government uses choice point so much is because of the Privacy Act of 1974. In 1974, Congress passed this law. Much of its purpose was to avoid the creation of a centralized database of information on Americans. There was a fear with the rise of the computer state that the federal government would create an agency, and that agency would just be a clearinghouse for personal information. So the Privacy Act passed. It incorporated many of the fair information practices that Nikki Ozer listed earlier. But what's most important about the Privacy Act is it says that an agency cannot collect your personal information unless it has a valid purpose to do so. And the valid purpose can't be, we're just curious, or you might commit a crime in the future. It's got to be a valid agency purpose. And so as a result, commercial data brokers like ChoicePoint can sit outside there, outside the realm of this law, collect all this massive amount of information about you. And when the government does have some purpose, when you do become a suspect of some crime, or if there is some agency pretense to get data on you, they can very quickly go to the commercial data broker and get this 18-page dossier on Chris. They no longer have to follow Chris around to figure out who his family members are, who his friends are, etc., or where he's lived. They can just pull this dossier. So we became aware of this some time ago and filed a series of Freedom of Information Act requests in June 2001 to learn about ChoicePoint, these other companies, how they're selling data to the American government. We filed our FOIA requests. As you might suspect, the agencies didn't respond at all. So we sued in January 2002, and that litigation is still ongoing. I just filed something in that case last week. But over the last 4 years that we've worked on this case, we have found out some interesting things about government access to commercial data brokers to your digital dossier. The first finding from our Freedom of Information Act documents, which are, by the way, are all available online if you'd like to read them, we scanned them all in and put them up. The first thing we noted is that there is a high degree of tailoring to the government. Commercial data brokers actually create products, ways of organizing personal information that's useful to law enforcement. So there are all sorts of add-on services that law enforcement can use in order to locate someone or to learn information about another person. For instance, the U.S. Marshals Service has a add-on an add-on feature with ChoicePoint that will alert them whenever a suspect's name shows up in any public record. So if you're looking for Chris and he's on the run, if I do something like open up a private mailbox, or if I get arrested somewhere, instantly the Marshal Service within a day gets a note that somewhere I've taken this action. Another thing we found is that there's very poor oversight of agent use of these databases. Our FOIA documents suggest that the federal agencies do not even audit their own employees' uses of these databases. And in fact, we have a memo from an investigation in the Department of Justice where an employee appears to have used the ChoicePoint database for a personal purpose. And they went to ChoicePoint and said, can you show us the audit log? Can you show us what this person searched for? ChoicePoint said, we don't keep those logs. We don't want to know what you're searching for. Well, then the investigators went to the agency and asked the agency, well, what did this employee search for? Show us your audit logs. And in this case, it was the FBI. The FBI responded by saying that no such log existed, and they weren't required to keep such logs. So there are literally tens of thousands of government employees who have access at their fingertips to these databases, and it appears as though they're not being audited. There's an international dimension to this. ChoicePoint collects information from all sorts of Latin American countries and sells it to the DEA and to the Customs Service. What's interesting is that when Latin Americans learned of this problem, they actually got angry and in some cases got the data back, whereas Americans have not reacted that way yet. Finally, the last thing I'd note is that almost all these commercial data broker companies are also direct marketing companies. And I hate to say we told you so, but the privacy community said in the 1990s that the rise of the direct marketing industry was going to create real problems for civil liberties. But it was a matter of time before direct marketing companies used their skills and used their data to collect information on people for the government. And the Direct Marketing Association fought this idea very strongly. They even have an ethical rule saying you can't use marketing data for law enforcement purposes. But everything seemed to change after 9/11, and we're finding that a lot of these companies either had their start in direct marketing or still have a significant direct marketing function. That's interesting. We've been very concerned about the use of commercial data brokers by the private sector. And so in December 2004, Dan Solove and I wrote a letter to the Federal Trade Commission arguing that the way commercial data brokers collect personal information and sell it may violate the Fair Credit Reporting Act. And that letter is on line 2, but the gist of it is that the Fair Credit Reporting Act regulates background checks. So if you, in an employment situation, have a background check performed, the Fair Credit Reporting Act protects you. That background check has to be accurate. You can challenge it. You can, if it's incorrect, you can correct it, etc. Well, what ChoicePoint sells is a type of background check, and it's often sold outside the employment context. So it's not subject to the FCRA. But all sorts of private sector entities are using it to make decisions about you. And you have no ability to make sure that it is correct or that you're being treated fairly. Somewhat complicating the situation is that shortly after we filed that letter, ChoicePoint and a number of other companies had disclosed that they were involved in very serious security breaches. One of those cases was settled yesterday by the Federal Trade Commission, where the Federal Trade Commission fined ChoicePoint $15 million. And I'd encourage you to read the complaint in that case, because what the Federal Trade Commission showed over and over is that ChoicePoint used sloppy methods to verify that its own clients were legitimate businesses. And in fact, if you read the complaint, you'll see that on the applications that these clients made to ChoicePoint, they wrote down data that was illogical or contradictory. So they would apply to use ChoicePoint, and they would use articles of incorporation, or they'll use a business license that had expired. they would apply as a business and use a cell phone as the principal contact, or a residential phone number as the principal contact for the business. So there was a fairly low bar to get into ChoicePoint's database, and that's what allowed these fraudsters to get access to so many people's information and commit identity theft. And this happened before. It happened 2 years earlier. A ring of identity thieves did the exact same scam on ChoicePoint and got through. And the reason why you didn't hear about that is that ChoicePoint wasn't required to disclose it, because between these two security breaches, California passed law to require a notification of security breaches. Let me just close on one thing. Am I cool with time? Yeah. Last year we made a big push to do something about commercial data brokers in Sacramento in light of these security problems. And it really exposes the problem that we have in privacy. And in the United States, we regulate privacy on a sectoral basis. That means individual industries have industry-specific legislation or not that protects data. And when you look at commercial data brokers and you say, I'm going to try to pass a law to give people access to these files, to let them correct their files, to do other reasonable things, to provide a better balance of rights, you realize there's a lot of businesses out there that do things, that perform functions that are very similar to data brokers, but they're often sacred cows, and they often can't be regulated. And so one of our biggest obstacles in trying to do something sensible about ChoicePoint was actually Google. Just think about it this way. Let's say you're trying to legislate a commercial data broker. Let's say that you want to apply a certain set of rights to a commercial data broker. How do you define one? You define it as a company that buys and sells sensitive commercial information, sensitive personal information to non-affiliated third parties. Well, when we came out with that definition, companies like Google said, wait a minute, that looks a lot like us. There's sensitive personal information in the Google database. We don't sell it, but we have an advertising model. It's advertising supported, which I guess could be called a sale. And sometime down the road, we might move into paid search. You might actually pay Google in order to make a search. And so Google wanted such a broad exemption to this commercial database broker bill that lots of companies would fall out of the regulation. Companies like ZabaSearch would fall out of the regulation. This is a company that sells your personal information to anyone. So in a way, it's worse than ChoicePoint, right? So just sell your social security number to the general public. And so I think that in conclusion, I think it's pointing out more and more the need for general norms of privacy protection in America rather than sectoral legislation. And in fact, there's a lot of support in this in the business community. Microsoft last year put out a policy statement saying it's time to start looking at this as a much broader problem and start to protect data no matter what industry it's being collected in. Thank you, and I look forward to your questions.
Good afternoon now. My name is Matt Parrella, and I'm the San Jose branch chief and also the computer hacking intellectual property unit chief for the U.S. Attorney's Office, the branch office here in San Jose, obviously. And I don't want to take too much of your time because I think that the question segment of this portion may be very important. But I want to point up a couple of things that have either gone unmentioned or have gone mentioned, and I think need a little fleshing out. With regards, and I'm sort of the representative of the government here, and I'm glad Professor Solove said that there were some nice people in the government, because I don't consider myself one of them, though, so that's where we're starting from. But anyway, in starting, one of the main precept that we work from, and when we're dealing with these issues in the government, and I should step back and just say a little bit further that what Mr. Hoofnagle was referring to, it tended to deal with a lot of governmental agencies and the FTC, various other aspects, and I think the Professor also did it as well. And really what I'm talking about is from a strict law enforcement standpoint. So on the one hand, we have the bad government sort of collecting data that people are upset about. And on the other hand, we have the good government, which is, well, when things go wrong, what happens? Who you can call? Don't answer that. But when we have a situation where we have a database that's hacked into and downloaded by, say, some Ukrainian college students in Minsk, and they send a ransom note, and they're going to post this on the internet if they don't get $10 million, well, that's a privacy issue. And that's where we get involved. And we've handled many of those sort of cases. When we collect data, especially in law enforcement, of course, the Fourth Amendment, which to me is more than adequate to address every need, certainly that law enforcement comes up against, but also just traditional due process considerations. So when I hear, as Professor Solove did, use the term, well, the government would just go to here or just go to there. Well, we don't just go here and just go there. I mean, I don't call people up and say, okay, Yahoo, send me your records. I mean, we have, legal process that must be followed in order to obtain those records, whether it be a grand jury subpoena. And I might add that in reference to the litigation with Google, that has nothing to do actually with my office. That's a civil case that's coming out of Washington, D.C., and so it's not involving a grand jury subpoena, so please don't ask me questions about it. But other than that the hearing will be in federal court down here, there's not much connection. But in any case, so we'll use legal process like grand jury subpoenas, search warrants, other somewhat lesser known process of 2703D orders, which came in and were extended in the Patriot Act. And these are all things that are, at least on some level, either previously reviewed by a court or has the potential subsequently to be reviewed in a motion to quash or a suppression motion or whatnot. So that is a tremendous protection that Americans have that shouldn't be overlooked or minimized. And to give you another example, with and I think it was talked about earlier. There was somewhat of not a confusion, but a use of the sort of the term surveillance, governmental surveillance, or law enforcement surveillance, in the same concept as data collection, or what I would call evidence collection. And really, while factually on the surface to a layperson there may not be much difference, but in terms of the legal process that's needed, there's a gigantic chasm between the two. If we're doing for a surveillance, what that would mean is real-time collection of data over the internet. Okay, think of it as a wiretap being run on a computer. And this is all, as I'm sure you know, perfectly technologically possible, and it is a law enforcement technique that is tried and true, and it grew out of the wiretap, both the wiretap technology and the development of wiretap law. And it's a perfectly natural outgrowth to it. There's a vast difference between that and the later collection of data, even though it might be some of the same data. For example, and to take it out of a computer stage, maybe put it into something that we may be a little bit more familiar with, the difference between running a wiretap on a telephone and obtaining what we call phone tolls, what phone number you dialed, is vast. The amount of legal process is vast. Same thing with a computer wiretap where, say, we're in real time capturing emails, real time capturing instant messaging or text messaging or something like that. That's an incredibly high burden in order to get a judge to sign off beforehand. And there are very strict requirements, and we're held to these things constantly. As an aside, I think it's somewhat funny that many of the European nations, which are sort of held up as models of civil liberties, have virtually no checks on wiretap regulation. And you can almost assume, if you're traveling there, certainly as a government worker, that your phone calls are going to be listened to, and that no judicial officer pre-approves or oversees, in certain countries, wiretap applications. It's just done by a government official who signs off, and there you go. So in that regard, please don't confuse those two concepts. And I would like to also point out that what I think potentially criminal law, federal criminal law, and law enforcement may be going towards, with relevance to this panel, we're seeing a situation like Choice Point. Well, this wasn't a situation where Choice Point itself was, or some other database itself was the criminal target. Someone else came in, and some fraudsters or hackers came in and took the information. And of course, there was a regulatory price that they had to pay, and there may in fact be some individual or class action suit or something like that, assuming they can show damages that the company may have to pay. But what we're seeing is more and more complaints about the negligent handling and securing of the data, and that by itself is not really gaining any traction in criminal law sort of conversations. But when it's tied to a downstream use of that data that is perfectly foreseeable, there may be a sort of a negligent theory that may be bandied around in terms of holding these data collection companies liable underneath that. So that's something that is sort of being discussed around. So in sum, I'd like to thank you for inviting me here, and again, I'll appreciate your questions. Thanks.
Good afternoon. I'll also try and be brief. My name is Anita Ramasastry. I came from Seattle, where I teach at the University of Washington. And Chris, can I have an internship at Epic? Because I'd like one too. I should first confess that by day, I'm actually a pretty boring, bespectacled commercial law professor. I teach all those UCC classes that students really hate, and I tell them I have to do it for the rest of my life, so it's my purgatory. But by night, I actually write columns about civil rights and civil liberties and their intersection with information technology. And fortunately for me, most of my colleagues at the law school actually don't know about it. They don't read FindLaw or CNN, and so they have no clue, and they just think I'm boring and mild-mannered. But what I'm going to talk about today is just the concept of adverse inference and the problems that we may experience as the government does more than dip its toe into the private sector with respect to commercial data. And so in the piece that I've written for this particular symposium, I'm trying to dispel the myth that I think a lot of people have alluded to, which is the question of what's the problem if the government peeks at my data. If they see what books I read, my library records, if they know my credit history, really who cares? I mean, that there's some psychic harm, it might make me a little bit more paranoid, but that there's really no effect. And I became interested in this, again, why my focus? Well, as a boring UCC professor, I'm also interested in consumer privacy issues and really became aware of data brokers because when I teach courses like Secure Transactions, I show a DVD called Repo Men Uncensored, right? So how do these debt collectors and the people that go around sneaking up and taking away your car, well, how do they find out where you are? And the DVD is marvelous, really amusing. But when I spend time and I actually make my students go out and interview in a law and action way, debt collectors and repossessors, and how do they find out where you are? Well, that's when I learned about this universe of data brokers. I had no idea, but how do you get people's phone records? How do you figure out where they're living and where their mom, dad, uncle, sister, and brother are? Because yes, it's the family members where you go and you hide or you leave the car. So I learned about this, and then I also had a personal experience. And so in the private sector, I think we're becoming aware of the harm of what I see as the error in databases, that there are lots of information that's aggregated and collected on us, and as Chris mentioned, if you buy your Choice Point Reporter, you get it, that they're going to give you what they think is your record, but that there may be errors or inconsistencies in it as data is collected and merged. And gosh, I have bad handwriting, so when I fill out applications, my age, my name, how it's spelled, there have been a lot of mistakes. And so those mistakes can have adverse consequences later on. Fortunately, there aren't a lot of Ramasastries in the United States, so it's actually good, right? I'm glad to have a unique name, although no one wants to pronounce it. But my husband has a really generic name. His name is Walter Walsh, and we live in the University of Washington's kind of university district. It's a pretty interesting area full of lots of transient people who come and go, and there's criminal activity. It's really lively, but we choose to live there because I want to walk to work. So my husband has an alter ego who lives in the same area and has changed apartments different times, and the other Walter Walsh, who's not a digital dossier, he's real, doesn't pay his bills at all. He's got a lot of unpaid debts, and we only learned of him as people started making phone calls to our house, and we got letters and we got knocks on the door, and someone tried to come trying to repossess my husband's car, but it wasn't my husband's car. So there was a lot of annoyance that was going on, and it took us a while, and I realized that there's got to be another Walter Walsh because these aren't my husband's debts. And my husband was also getting pretty upset. Eventually, we found the man, and he was working at IHOP serving pancakes. He was actually a pretty nice person, but just down on his luck. Well, that was fine, but a little while later, we were refinancing our mortgage, probably for the 5th time, to get a better rate. And we got a phone call. We were about to close. We were going to get the loan, and we were told, your husband lied on his loan application. Why didn't he tell us that he'd filed for Chapter 7 bankruptcy? And I said, well, he didn't tell me either. So, so I had to say to him, honey, is there something you aren't telling me? And it was only because we knew of my husband's alter ego. We knew that he lived in the same area, and we knew that there had been some problems with data merger, that this was probably happening. And only because I knew as a law professor that I could go on to Westlaw and look up bankruptcy records, in a matter of minutes I was able to actually pull this other guy's social security number, name, and filing for Chapter 7, fax it to the bank, and our loan closed. Had I not been able to do that, the adverse inference that was made and the error would have been quite detrimental economically to us in terms of the hardship of not getting the loan. So that is really just in the private sector, that error and inaccuracy in private data collection can have true harm. But what about when the government reaches in? And that's really what I'm trying to examine now. And I think that's what's hard. The newspaper journalist that was here earlier from CNBC was saying, I need a story. And in terms of the stories, what are they? Well, the example that I want to really look at is the issue of airline passenger profiling, because this is probably the most palpable example we have now of the federal government for terrorist prevention and detection wanting to look at personal data that's held by commercial data brokers. And there are 3 different instances or ways in which the government's interested in monitoring people who fly on airplanes. The first one is the no-fly list and the selectee list, the list that exists already, which identify people who are either potential terrorist suspects or who have some affiliation in terms of being known associates of those. And there's a real question, and if you read documents on EPIC's website and others, of how that list is compiled. We're not really sure how you get onto the list, but one of the first concerns I think we should have is, is commercial data being used to put us onto a list? Because if that's the case, we really want to make sure that that data is accurate before we're on a list that's going to have consequences. And I think the no-fly list is one example where, up to 30,000 people have been erroneously put on the list in some way because their name may resemble somebody else's, and you're not really sure how that's happening. The second example is CAPS, and really CAPS 2, which is computer-assisted pre-screening passenger profiling. And it's already existed during the Clinton administration. It was used but as a baggage screening device. Again, trying to figure out who's on a list, who might be a suspect, and then making sure that their bags were not containing explosives or bombs. But CAPS 2 was something that was proposed by the Department of Homeland Security and the Transportation Security Administration as a way of actually color-coding each of us, right? That we were going to be coded as security risks based not only on data that the government possessed, but by looking into the private sector to data brokers to see if there was a consistent record in those databases, meaning, was there a verifiable address? Had we lived at it for a long time? What was it that the database could tell about us that might predict whether or not we're a risk? And I think that's where accuracy is really important. When risk assessment is being linked to data, which is not subject to the Federal Privacy Act, where there may be errors, where data may be merged incorrectly, where it may not be everything. And again, the vigilance that's necessary to not only monitor your credit report to make sure it's accurate, but then if you can't correct what the data broker has, then this notion that somehow it's being fed into something that's going to color code you and decide whether or not you're a threat, that's where the palpable harm begins, right? Will you be denied boarding? Will you become someone that is subject to further scrutiny on a routine basis if you're a frequent traveler? And so I think we need to be careful. And of course, CAPS 2 was abandoned because computer scientists and privacy rights advocates really said you've got to be careful when you start using this data for risk assessment purposes. And there was a students who wrote the MIT paper about the carnival booth saying, in terms of prediction, terrorists can really decide or figure out what it is that you're looking for and then just evade that, so that its predictive value may not be that great. And then the third is the example of secure flight, that once CAPS was abandoned because this idea of coding us was seen as bad, that the government said, okay, we want to now instead use data from the private sector to just match it and look at what's already on our terrorist watch list, our no-fly list, just to see, okay, do we have the right person? Is there a threat? And so it was sort of an enhanced way of looking at and matching. So the third instance of why private data might be used is really to match and to verify identity. And while it's perhaps not as worrying as this notion of risk assessment of everybody, there's still the issue of the false positive or the false negative and making sure that the data is correct. And in terms of harm, again, one of the things that gets mentioned more in the private sector, because we talk about things like credit scoring and insurance risk assessment, is really the fact that certain classes of people, to the extent that we're starting to rely on private sector data, which may be inaccurate, may impact certain classes of people more than others. And those classes of people include students who move around a lot, younger people with perhaps less robust credit histories, minority groups, the poor. And so really, again, in terms of who may feel the harm of using private sector data for government purposes, I think we really have to be careful that certain kinds of private sector data do not become proxies, either deliberately or inadvertently, for certain kinds of discrimination. And so how do we deal with this? Because again, I think there are reasons why private sector data can help clear your name. And make sure that you're not put on the list. I'll just mention one other example, too, of a palpable example of how using private sector data has been harmful. And this one is much more international. After September 11th, the U.S. government, and through executive order, froze the assets of a large number of companies, entities, and people that were alleged to have links to al-Qaeda. And based on that list, in the U.S., assets were frozen. The Security Council took that same list and, without vetting it, basically said that the United Nations members had to comply with the same asset freeze. a man who was a Somalian refugee in Norway, and there's many other examples, woke up one morning to find out that because his name matched someone's on a list that was created in the United States, that all of his assets were frozen. Okay? So if you use the Kafka metaphor, I mean, when he finally figured out how this had happened, you know, the economic impact of having no access to what is your property was quite surprising. And that really brings me to the larger issue, which is that if we are going to have the government looking at private sector data, we need to ensure several things. One is due process, and EPIC and other nonprofits have been looking at this issue of how do you get your name off a list, or if there's a mistake, how do you correct it? And so the TSA and Department of Homeland Security are responding now and are trying to provide due process, because there have been lots of stories of people trying to get off lists and can't figuring out how. And it's the same with the United Nations and with these orders that froze people's accounts. There was no, and today there is no, due process with the United Nations once they decide to actually freeze your assets. So due process is important. The Federal Privacy Act, I think, is another issue. If you're acting as an agent of the U.S. government, what duties and responsibilities should you have to make sure that the data is correct? If the federal government discovers that the data is incorrect and clears your name on the government side, should there be a corresponding flow back or duty to correct it? Meaning, how are these two, the private and the public, going to work with one another? And if there's an error in one place in either side and it's corrected, should there be a flow through so that we don't have a repeat problem later? And then I think there's just the larger issue that Professor Solove mentions, which is really context. I'm a big fan of Helen Nissenbaum's writing, because I think we really need to start thinking about when we give out information, we do have certain expectations. And if we can't even imagine where the information is going to go or what it's going to be used for, how can we as individuals make decisions? And I'm going to close by saying, and there are ways in which we harm ourselves by being human. And one example of that is the fact that I think that when we give out information in a particular context, we may not always be accurate or truthful. And I don't mean this in a bad way. That we may not want a certain party to know something about us, so we might either lie or obfuscate or just omit. And to think that those subtle omissions could come back to be used in a government context many years later, I think is quite dangerous. And that's where we need to also really look at what the technologists have to say, because it's also about how the information is categorized. So that in one employment questionnaire, you might say that you've never been convicted of a crime, and maybe the word crime was defined as felony. But later, when that information is coded into a database, you're listed as someone who's never been, and maybe you had a misdemeanor at some point. And so the example is, again, just what you're responding to may not easily translate when it becomes stored in a database and used later for analytical purposes that were different from the original. So context is so important, and that's why I think we really have to focus on the fact that consent to disclosure of information is not enough. But lying can be bad, and I'll close with this one story, which is that I once was, when I first started becoming more zealous about privacy, I decided I would just lie to MSN, and I think I told them I was 12 when they were my internet service provider. Well, it took me 6 months to get my email unblocked because they kept telling me I needed my parents' permission, and I had no parents to give permission for me, and I couldn't get a live person on the phone. So I have really hysterical letters and emails that I sent to the company repeatedly as I tried to convince them that I was really a woman in her 30s. So thanks very much.
I want to thank all of our panelists, and I believe we have about 10 minutes or so to open up the floor for questions. Professor Ochoa.
This is a question for Professor Nehf. And you said, well, we need to reconceptualize this so that when we're gathering information, there's conspicuous disclosure as to what's going to be done with it. how are we going to regulate the problem of conspicuous disclosure, right? Because, the ordinary company says, well, I am disclosing, right? There's a privacy policy that you can go to, and of course, you click on it, it's one of these, long-form, license, type agreements that's got lots of information, says we can do anything we want with it. But, there is a place you can go that says, here's what we're going to do with the information. Right? What's conspicuous disclosure? And if we have to disclose that conspicuously, are we going to end up having, 10 sheets of paper attached to every registration card? Right? How do we regulate that in a way that makes it effective without making it overkill?
It's a good point. The answer, though, is what I'm arguing for, and what many others have argued for, is really to shift the burden. Instead of kind of the default being you get everybody's information unless they take the initiative to somehow opt out or hide it from you, you have to find a way to get it affirmatively. And your argument sounds very lawyerly, right? What's the difference between a conspicuous disclosure and an unconspicuous? But in many contexts, in consumer contracts with separate initials in paper contracts, or separate in the computer, separate boxes to click, which we do see to a great extent now when you sign up and you agree or not to get junk email, and you can click or not click. If we had more of those, I think that would help quite a bit. Now, I think what would happen is, if we did have a law that said you had to have affirmative permission to take somebody's information and use it in certain ways, it would be extremely difficult in many circumstances and burdensome to do that. And companies would make the economic decision that it's just not worth it. To me, that would be fine. That would just be fine.
Jim Harper from the Cato Institute. I wanted to ask the first three speakers in particular, all of you made a good case that there are a lot of problems, and there are a lot of problems, but I want to ask a little bit about solutions. Chris and Daniel, you both put forward a model, I suppose fair information practice style regulation. Professor Nehf, you mentioned fair information practices and FTC Section 5 enforcement as well. But in substantial respects, we already have examples of this, and we have the problems we're talking about. The Fair Credit Reporting Act is a 30-year-old law that was supposed to bring us fairness in credit reporting, and if anything, dealing with credit bureaus is Kafkaesque. The Fair Trade, the FTC, already has Section 5 authority, and so Professor Nehf, your argument that they should make these decisions is equivalent, if you will, of saying, well, if I were king, I would. So how are these proposals practical ways of moving forward, knowing that the FTC already has this authority, that there's already fair information practice law in the books that isn't working well? What are your prescriptions for solving these problems?
If I could answer just real quickly. With respect to individual enforcement by the FTC and state attorney generals, yes, they have the power. There's no question about that, but they're not using the power. Now, it might be a question of resources, but I'll tell you, with the Federal Trade Commission, when at the end of the Clinton administration, the FTC's position was we need to have stronger nationwide privacy standards. What they would have looked like, who knows? But when the next administration came in, they went more toward this market approach, and what the chairman of the FTC said was, we're going to let the market work, and we as market regulators will step up our enforcement efforts. So they were, they had represented that would be done, and I just don't think it has been nearly as aggressive as it should be.
I think your point sort of assumes that the laws that have passed have actually been like perfect. Like we have the right institutions, the right set of laws, and this, the problem is that the laws have been to some extent circumvented. There have been exceptions and explicit loopholes that have been popped in by companies and others who don't want to be regulated. That a lot of the fact is we have like selective incorporation of fair information practices into laws. I think that the Fair Credit Reporting Act, although there's certainly a lot of problems in the law and there's a lot of difficulties, has done some good. There have been some advances. So to say that because we kind of have built a kind of incomplete and imperfect set of regulations with agencies that are deeply flawed is not necessarily to say the project should be abandoned. There are certainly ways that this project could be improved and fixed. I just don't see how alternatives such as the market self-regulation mechanism or some kind of decentralized tort regulation system that you have pushed will really be effective. And so I think that the way to do it is make sure that we have a better system of regulation, because I think we have actually had some success in that realm. But there's certainly, I think you're right, there's a lot of work to be done and still a lot of existing problems with the way it's working.
I'm thinking through your question, Jim, and I can't say that the FCRA, the Fair Credit Reporting Act, is a unilateral success. But what I can say is that we're better off with it than without it. Prior to the passage of the Fair Credit Reporting Act, you did not have a right of accuracy in your credit reports. You didn't have a right of access. And the investigators actually made money by reporting negative information about you. And so think about what was negative in the late 60s. The investigator would come to your home, look at your home. If it wasn't clean, they would write that down. House is unclean. If they found a woman living with a man outside of wedlock, that would be reported. If they found a man living with another man, they would report that you were homosexual. They would make things up because the greater risk that they could show that you were, the more money they got back from the insurance companies. So I think, to amplify what Dan said, it's not a perfect situation, but it's better than it would have been. And I think the main point of the Fair Credit Reporting Act that we need to apply over to the commercial data broker side is that credit reporting agencies are under an affirmative burden to retain accurate procedures. And that cuts down on some of the problems that Anita mentioned. It doesn't completely eliminate them. But when you switch over into the choice point realm, there are no standards. So, for instance, I have a pretty unique name, but if they find a criminal record on someone with the last name Hoofnagle in Maryland, where I used to live, they'll stick that criminal record in my file because I share the last name with someone and I used to live in Maryland. And that's the type of logic that happens. So that's the type of inferential logic that exists in an unregulated scheme that cannot be tolerated in the Fair Credit Reporting Act scheme. That conviction would not come over under an FCRA regulated database.
I guess I'll ask one last question to wrap things up before we start for lunch. A lot of you have suggested, just now with the Fair Credit Reporting Act not necessarily being, we're better off with it than without it, but it's not necessarily a construct to deal with the problems we have now. If you consider the time frame when the Credit Reporting Act was developed versus the phenomenon of commercial data brokers now. Anita, you referenced when one record is corrected, how do we ensure that one record sort of filters out down the stream to the rest of the records? Is there some need, no one likes to say the government needs to overregulate, but is there a need for some more centralized regulation? Some states have made efforts on their own to do it. California tried, it ultimately failed. But is there some need as a, federal to kind of govern this phenomenon in privacy in general? And I'll pose that to the entire panel. Or whoever wants to
just
speak.
Hit on the line. I think it makes sense to start at the state level and figure out a couple different approaches. A lot of the most effective aspects of the Fair Credit Reporting Act are actually California laws that were grafted onto the federal standard. But the federal bills that have been introduced to deal with commercial data brokers aren't going to solve some of the problems that Anita talked about and the problems that Dan talked about. And generally, the federal bills are much weaker than the bills that are being discussed here.
Yeah, I would ditto that. I think that it comes to some of the pathologies of Congress that don't necessarily exist at some of the state levels. I mean, I used to be very much in favor of, federal solution. We're in an information age. How can we have all these different state approaches? But in just sort of seeing just how, to some extent, out of touch Congress can be in a lot of cases, how difficult it is for anything to move in Congress, and then how something ultimately gets whittled down with so many exceptions and exemptions and whatnot in Congress that it seems like very, very hard to really look to Congress to say you really can get a meaningful piece of something through that's experimental, that if it doesn't quite work right, you can go and fix it. It's just that it's a kind of a very difficult, the pathologies in Congress as an institution might prevent a really effective federal solution. Now, not to say we shouldn't try, but I think that the states can try out a lot of things that have proven very effective, and I think California is a great example of things that have actually worked and that ultimately have informed the national debate over what can work and what might work in the future.
Just one quick thing to put it in a little broader perspective. The interesting thing is in the golden era of consumer protection, consumer advocates went to the U.S. Congress. This was the late 1960s and the early 1970s when most of these, the stalwart consumer laws were enacted, including the FCRA. Consumer advocates pretty much stuck with that philosophy for many, many years, but it has flipped completely around. Now, for political and other reasons, the most innovative consumer protection is coming out of the states. And one of the advantages of that is experimentalism. You get a chance to see what works and what doesn't, and then maybe the federal government can grab on to the things that are most effective after the experiments have taken place.
And I have just a sort of comment and question for Chris, really, which is also that to the extent we're talking about commercial data brokers being used for government purposes, the interplay of the Federal Privacy Act and whether or not there should be.
That's an incredible difficult problem to resolve, because the government is talking about regulating a service that they themselves use. And one of the bizarre ironies is that there are all these attorneys general in the United States who, on one hand, are investigating ChoicePoint for security lapses, and on the other hand, they all have subscriptions to it. So there are some challenges there, but I do think that the Privacy Act foresaw the day where the private sector may become a source of personal information, and so in the Privacy Act there's subsection M. However, it's so narrow that it doesn't capture ChoicePoint. They hit, but they missed, so they got half the problem there.
I'd like to again thank our panel for their time today.